Some
Yes.
supplementary list. Item number 1.
May it please. From the state side, my lord, names have
Oh,
been.
yes, 3-member committee.
Yes, my lord. We have agreed on name of Sri Tribor Lang Jerua, advocate.
What about
And the IAS officer is Mr. E. Kharmalki from the state side.
Kharmalki? Is he presently in office, or
No, he retired, my lord.
he is a retired IAS,
Retired.
IAS officer?
Yes.
Member committee said once. Very well. Please take on. This is the daily list.
My lords, we are challenging the notification issued by the state government applying the PNSS to the appointed district council officer, judicial officer in the East Kazil districts. My lord, I've come across lordship notification recently. The lordship said that any matter relating to tribal would be taken up by the division bench number 2. Otherwise, my lord, I have no difficulties, my lord. And this writ petition itself, my lord, it relates to my lord, the courts constituted by the district council, East Kazil district council. Earlier, my lord, the CPC is not applicable, only spirit is applied in this tribal area. Now the state government, by virtue of that notification 2022, has extended the CRPC, now PNSS.
Now it is extended.
Extended, my lord. And now this will apply to the tribal areas. So therefore, my lord, I'm just bringing lordship notice whether matter needs to be processed before lordship or need to be listed before the DB number 2. Otherwise,
But I think that there is a judgment of the Honorable Supreme Court where the Supreme Court has, where the issue was with regard to the appointment of the judge by the district council in relation to the criminal matters. So that one notification was there, and
Yes,
the power of the state to appoint a special judge for trying that offence was, I think, the matter went up to the Supreme Court.
yes, one
Well,
of the matter is there, my lord, and
that operative portion of that, my lord, the judgment
in
pronounced by
that
this court
case,
is state.
One-
lordship,
But
that was the
in that
case. That was a case where the Honorable Supreme Court has to examine the issue that the case was being tried by the district and session judge, Nongstein, my lord. And there was a notification conferring power on the district council to try the cases under paragraph 5 of the 6th schedule.
that is in the 6th schedule.
Yes. Now, this was a judgment before, because the Honorable Supreme Court took note of the provisions of CRPC, and the Honorable Supreme Court also, in that judgment, took the aspect into consideration that there is no notification extending CRPC in the state of Meghalaya.
Yes.
That was the reasoning or basis of that judgment, and therefore the cases will be tried by district council court because power has been conferred by state government on the district council court. This was the judgment prior to issuance of notification under CRPC. my lord.
Now the notification has been issued.
And that notification is under challenge.
Is under challenge, extending the provisions of the CRPC,
CRPC
or
to the state of Meghalaya.
to the state of Meghalaya.
Yes, my lord.
But how that militates against the provisions of the 6th schedule, because
Yes,
any
ma'am.
offence
My lord,
would be an offence against the state.
my lord, under paragraph 5.1 of the 6th schedule, once the governor, my lord, confers certain power to the officer of district council,
District council has to be
district council,
offence is defined under the IPC and the procedure in the CRPC.
right?
So this power,
My lord, can you see paragraph 5?
yes,
The citation judgment your lordship was referring to, citation is, my lord, 2023 SSC page 711. State of Meghalaya versus Melvin Solanki.
yes.
Melvin
That is clear.
That is
2023, yes.
yes, 2023 SSC. Sir.
It's informing.
So, my lord, can you see paragraph 5 of the 6th schedule? paragraph 5, so paragraph 1. My Lord permits me to read out, my Lord.
Yes, please.
It's a conferment of powers under the Code of Civil Procedure and Code of Criminal Procedure on the Regional and District Council on certain courts and officers for trial of certain suits, cases, and offences. The Governor, for the trial of suits or cases arising out of any law in force in any autonomous district or region being a law specified in that behalf by the Governor, or for the trial of offences punishable with death, transportation for life, or imprisonment for a term of no less than 5 years under the Indian Penal Code, or any other law for the time being applicable to such district or region, confer on the district council or regional council having authority over such district or region, or on courts constituted by the such district council, or on any officer appointed in that behalf by the Governor, such powers under the Code of Civil Procedure, or as the case may be the Code of Criminal Procedure, as it deems appropriate, and thereupon the said council, court, or officer shall try the suits, cases, offences in exercise of such power to such conferred. Now, I agree with the para 3, Lordship Majesty. Now, Governor has already exercised para 5.1. Now, para 3 says, save as expressly provided in this paragraph, Code of Civil Procedure or Code of Criminal Procedure, such shall not apply to the trial of any suits or cases or offences in any autonomous district or any autonomous region to which the provision of this paragraph already applied. So my grievance here, my Lord, is that Governor has already exercised his para 5.1, conferring powers to the officer of district council, and trial is going on. Now, over and above, Governor now extended the CRPC again. So my humble contention is, my Lord, once Governor exercises his power, confirming power under 5.1, but the question of application of CRPC under para 5.3 doesn't arise. But subpara 5.3 has a prohibited application of CRPC. That is one of the ground. And other ground is also there.
No, so the Governor has conferred power under 5.1.
5.1 already, my Lord. Yes. He has already conferred long ago and even continued. If I have an next 1,000 confirming notifications.
So conferment of power was on the district council or
Yes.
the regional council as a case.
Officers,
This
madam.
conferment power was given by the Governor.
My Lord,
To
officers.
be tried
Yes, officers.
by the officers,
Yes,
but these are all judicial officers appointed by the state,
by the district council.
by the district council, maybe on the recommendation of the Governor of the state.
With the approval of the Governor.
Yes.
Yes.
Now,
And those notifications, my Lord, can you see
trial of any suits,
130 of the
cases, or
repetition.
offences. No, so what is the subject matter of challenge now?
Now, my challenge is, my Lord, Lordship, can you see page number 130 of the writ petition?
130.
130. One 130 to 134. my Lord. Well, it says, my Lord, 1989. In exercise of the powers conferred by subparagraph 1 or paragraph 5 of the 6th Scheduled Constitution of India, the Governor of Meghalaya is pleased to confer on certain such judge, Councils or district councils court, who is thereby appointed by the Governor as the officer for the purpose of aforesaid paragraph, the power for trial of offences punishable with their transportation for life imprisonment for a term of not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to the Khasilas Autonomous District Councils. So this was continued. I may straight go to the last conferment 134.
No, you are challenging which one?
This is the first conferment. Now I would come the last conferment. You will kindly see page
But
number
what you are
134.
challenging? What is
My challenge is, my lord. I'll come.
Which action of the state you are challenging?
Yes. Now my challenge is, my lord, page number 139. My lord, kindly.
139.
Yes, 139 and 140. 139 may. In pursuance to full separation of judiciary from the executive and in exercise of the power conferred in proviso to subsection 1 of subsection 2 of section 1 of the Code of Criminal Procedure Code, the Governor of Meghalaya is pleased to apply the provision of the Code of Criminal Procedure 73 to the courts in the state of Meghalaya. The District Council Court shall continue to derive powers under paragraph 4 and paragraph 5 of the 6th Schedule Constitution of India. Now he has applied. And now, in view of the arrival of the new PNS is, my lord, page number 141, the next page. Since CRPC repeal already, now the new act, page number 141.
So this is a notification which has been issued by the governor.
By the governor under subsection 1 of section 2 of the CRPC.
Yes.
Applying the CRPC to tribal areas,
Yes.
including those areas. Now, as
But the limited power of the district council has also been retained.
power is
District
retained.
council courts shall continue. This power is
One.
with the governor under 252, paragraph 52. The governor may withdraw or modify any of the powers conferred on a district council, regional council, court, or officer under subparagraph 1.
One.
So this power is exercisable by the governor under 52.
5.2, he can modify. Lordship is correct. But my grievance is that, my lord, once a para 5.1 is invoked, para 5.2,
See, 5.1 is not absolute in terms because the constitution, the constitution, the Constituent Assembly also debated on this, and the makers of the constitution has also consciously given a power to the governor that if the exigencies arises, and with the change of time, that is why 5.2 was there. So this is a power exercisable prima facie under 5.2.
but with respect to submission, it is not under 5.2.
Sorry?
It is not under 5.2. But once 5.1 is applied, 5.3 says that governor cannot apply the CRPC to those cases tried under 5.1. That is my contention. And governor has admittedly conferred under 5.1. So once he conferred under 5.1, authorizing that particular officer to exercise power under CRPC, the question of issuing another notification under 5, applying, my lord, CRPC, under CRPC, my lord, subsection 1 of section 2, because that application
This is in fact the application of CRPC or CPC as the case may be.
Yes,
This power was there in under 5.1.
5.1.
5.1 in this state.
So 5.1 says that because these offences are to be tried under some law. So for any criminal offence, it has to be the CRPC or IPC, previous CRPC, IPC. So whoever is being designated for that purpose, that court, is exercising a power under the CRPC
Yes,
for the purpose of trial of that.
yes,
So this district council or the regional council was given the power, conferment of power to constitute the court, and that is you have seen us at page 130. You have shown us page 130 for the purpose of conferment of the power on the district council,
yes,
and an officer was appointed, judicial officer,
yes.
to try the offences.
Those serious offenses.
Yes. Now, what the governor has done on 20th September 2022, taking into consideration the separation of power, executive of the judiciary, and taking note of this criminal procedure code, has applied the criminal procedure code to the coastal state of West Bengal, to the state of Meghalaya, But it has also retained the district council court's power. The district council court shall continue to derive powers. So he becomes a district council court. He's a judicial officer to derive powers under paragraph 4 and 5. So how you are agreed by this?
My lord, because the September, my lord, 20 September 2022, governor exercised power under CRPC, applying CRPC. It's not under the para 5. Now, para 5.1, he already exercised. And due to conferment, my lord, that particular officer is exercising power under the, my lord, CRPC.
Now, the officer, when he appointed as judicial officer for the purpose of trial, all the provisions of the CRPC should apply.
Yes.
Whether it is taking cognizance, framing of charges, trial of the trial of the offence, these are all the procedures to be governed by the CRPC.
CRPC.
And it is a procedural, substantive is your IPC.
Yes.
Correct? So, this only thing that the courts to be established by the district council.
Yes.
The officers are to be given by the state, nominated by the state, and they were under the control of they will be considered to be a district council courts. Now, what the governor has done, taking note of this, the governor said that the district council court shall continue to derive powers. Whatever the powers 4 and 5 is, I think, under paragraph 4 and 5.
Yes.
So under
Paragraph 4, my lord, these are the offences less than 5 years punishment. Lordship, can you see paragraph 5?
Yes.
Paragraph 4. Paragraph 4 of the 6th statute.
Yes.
It says, my lord, regional council for an autonomous region in respect of areas within such region, and district council for autonomous district in respect of areas within the district other than those which are under the authority of regional
So
council.
paragraph 4, power of the district council is retained.
Power of the, my lord, district council court to try offences less than 5 years is retained.
Is retained.
Provided, my lord, both the parties are tribal, coming from the same district.
Yes, so 4 is, you cannot have any grievance that 4 is retained.
Yeah, 4 is retained.
So far as 5 is concerned, district
5
council
is-
will continue to derive powers under 5.
My lord. Therefore,
That is also retained.
my lord. So, my lord, 5 under 5.1, governor retained the power. If he doesn't want to invoke 5.1, these serious offences will be tried by the regular district court, district session court. But if the governor, applying his mind, then I can confer this power to the district council officers also. Then once he invoked that one, para 5.3 says that CRPC cannot be applied to those officers. And here now he has applied. That is the issue, madam. I'm not questioning the power of the district council officers under para 4.
You are saying that the exercise of power by the governor under CRPC
Yes.
is prohibited by reason of 3.
3, madam.
3.
3. Because he has already invoked para 5.1. Had he not invoked
But still
5.1,
he retains the power under 5.2.
yes.
See, it's a important as a source of power. Whatever he may have mentioned in the notification is not sacrosanct. In a judicial review of an action, you have to find out what is the source of power.
Yes.
If it had been exercised under 5.2, then it's perfect. Merely because the governor has referred to the provisions of the CRPC for the purpose of conferment of the power, let's put it this way. If this same power is exercisable under 5.2, then it's valid.
But my with profound
No,
respect.
please,
Yes.
as a proposition of law, let us understand this.
But,
If this power is exercisable under 5.2, according to you, whether that was possible for the governor to do so or not.
but governor can, my humble submission, my lord, under para 5.1 he can confer. And para 5.2, sub para 5.2, he can modify it. But
So basically what the governor has done in this case, basically this is in effect a power under 5.2. Suppose you read this notification, because our purpose is not to invalidate it. to validate this if it is supportable by the power.
Yes.
It's not the section that is important for us. It is a source of power.
Yes.
So what you are challenging is the source of power,
Yes.
not a malefic exercise of power. So according to you, this has without jurisdiction,
Yes.
or is a clear bar
Yes.
in view of paragraph 5.3.
5.3.
But please look it from the point of view of 5.2.
Therefore,
If the governor has a power to may withdraw or modify any of the powers. So here in fact he is modifying the powers of the district council. So in effect, you see, there is, as such, it is not being affected because a judicial officer is appointed for the purpose of trial of an offence. So normally conferment of power on the district council, but the officer appointed is a judicial officer, is from the cadre from the judiciary. So it is not that the district council could nominate a person of their own choice for the purpose of trial. So it necessarily implies that the person to be appointed would have some qualifications, who has to be a judicial officer with some experience, whatever the rank of a session judge, because if it is more than 5 years, or with imprisonment of life sentence or death sentence, whatever is there. So these trials can only be, these trials district council cannot say, or that is also not the object of the fifth paragraph 5, that it can be done by anyone who has no legal background. So fall back on the judiciary. So what the governor has said, that there is a separation of power between the executive and the judiciary. So these offences are to be tried by the judiciary. So he gives a reason for the separation of this as for the purpose of exercising a power to modify the conferment of the power which was given in 1989. So what is the real challenge to it? Let us understand.
My lord, my humble submission is, my lord, had governor not exercised para 5.1, then he can invoke the subsection 2 of section 1 of the CRPC, extending the CRPC to the district council courts. Now, once he invoked 5.1,
Yes.
my lord, para 5.13 prohibits application of CRPC. Lordship, I have no quarrel.
No, that is-
he has the
no,
power to modify.
See, that is,
Yes.
it's only the language that is there. If the governor says I am exercising a power under paragraph 5.2, then that portion goes. We understand your point. It says that this particular section, the conferment of power, is spared because of 5.3. But this power is otherwise available to the governor under 5.2. But technically, your friend is correct.
Yeah, I will just, my lord, kindly see 5.1 once again with me, my lord. 5.1.
Yes.
And marginal note, your lordship may kindly see marginal note also. Conferment of power under the Code of Civil Procedure and Code of Criminal Procedure 1998 and Regional District Council, my lord. Kindly, the governor may, for the trial of suits or cases arising out of any law in force in autonomous district or region, being a law specified in that behalf of the governor, or for the trial of offences punishable with death, transportation for life, or imprisonment for a term not less than 5 years, under Indian Penal Code or any other law for time being applicable to such district or region, confer on district council, now my lord kindly, or the regional council having authority over such district or region, or on courts constituted by such district, or on any officer appointed in that behalf by the governor. So even the governor can appoint and such power under Code of Civil Procedure, or as the case may be Code of Criminal Procedure, as he deems appropriate, and thereupon the said council court shall try the suits, cases, offences, exercising of power so conferred. My friend's case is, my lord, that by notification under paragraph 5.1, power has been conferred on the judge established or court established by the district council. Now he will try the cases under the IPC offences without procedure established by law, that is without CRPC, because 5.1 is not using the expression. In notification, expression CRPC is not used. Because there is a procedure, and I have answered to that aspect also, my lord. Kindly see the section 2 of BNSS first. Your lordship, kindly see section 2 of BNSS. Section 2 of it says that
section in the CRPC.
it's a section 2 only, my lord.
Give the BNSS all those books are required now.
One subsection 2, my lord, sorry. Section 1, subsection 2. Lord, the provisions of this Sanhita, my lord, lordship.
Yes, extension of, but the state government may by notification.
Yes, by notification apply such provision. So under CRPC or BNSS, this power is conferred on the
state.
State to by virtue of exercise of that power, it has been extended in the state of Meghalaya, in the all courts. Now, your lordship has seen. Then in paragraph 12A also I have pointed out. Paragraph 12A says that anything 12A gives blanket power that all these law will have overriding effect. Lordship will see application of acts of parliament of legislature of state of Meghalaya to autonomous district and autonomous region in the state of Meghalaya, notwithstanding anything in this constitution. And B is exemption. President may, by with respect to any act of parliament, by notification direct that it shall not apply to any autonomous district or autonomous region in the state of Meghalaya, or shall apply to such district or region or any part thereof, subject to exceptions or modifications as he may specify in the notification, and any such direction may be given to have retrospective effect. So there is no exemption exempting the application of CRPC, my lord, or BNSS to the state of Meghalaya. It is a parliamentary act, my lord. And 12A starts with non-obstante clause, my lord. That is one, my lord. Now, your lordship has...
No, here he said...
Yes, my lord.
That in view of 5.3...
Yes, my lord. Now, your lordship, kindly come back to this argument. Your lordship has already answered that if I have the power to confer or power to apply, the nomenclature title may not matter, my lord. Or source will, because if I have the source of power, my lord. And two also, your lordship, kindly see the governor may withdraw or modify any of the powers conferred on district council, regional council, court or officer.
But here the exercise of power is not under 5.2. That is what he says.
If your lordship will see, even in part 3
but
also.
Mr. Counsel, if the governor exercises the power under 5.2, then what is your answer? What would be your answer?
My answer would, my lord, before he exercised that one, my lord.
Sorry?
He has to, my lord, revoke his conferment under para 5.1.
The governor has a power under 5.2.
And
so if the 5.2 is there, then 5.3 is this, that the shall not apply to the trial of any suits.
Yes.
Now this is now expressly provided in the paragraph is paragraph 1.
Yes, ma'am.
Fee qualifies 1.
Yes.
So for all these offences, CRPC or IPC will apply. So say was expressly, so this is 3
yes.
is restricted only in rest to the trial of any suits.
Yes.
trial of any suits, cases, offences to which the provisions. It's not a question of conferment of power. 5.3 is not a conferment of power. 5.3 only says that these provisions shall not apply to the trial.
Yes.
But conferment of power is one.
Well, confirm is only.
So
No, she was correct.
5.3 is only in respect of the trial, only those part of it,
The
not on
procedures.
conferment of power.
Well, the procedures.
Procedure.
The procedures.
But this is the conferment of power under 2.1 is not excluded by 5.3.
Yes.
But my humble submission is, my lord, once governor, my lord.
5.1 is a conference.
But para 5.1, it
Yes.
says such powers conferred under the CRPC. Now, to try those serious offences, my lord, punishable more than 5 years.
Exactly. So this 3 takes care of the nature of the offences. So CRPC or this Criminal Procedure 98 shall not apply to in respect of any other trials not expressly saved by one. But this is nothing to do with the conferment of power. There are 2 parts of this. 3 takes care of, suppose there is one offence and that is sought to be tried under CRPC, which relates to paragraph 5. And this is not permitted because you cannot apply the provision of CRPC to any offences not covered by this Act.
That is true, my lord. But now, in view of the 2022 notification, my lord, these CRPC stands apply to these officers also, appointed under para 5. To the officers appointed under para 5.
Limited to the offences in 5.1.
That is why, my lord.
Limited
Therefore,
to
my
the
lord,
offences of 5.1, not beyond that.
therefore, my lord, my humble submission is para 5.1, para 5.3 prohibits application of CRPC to those offences.
Application of the CRPC here was with regard to, what does it say? It regards to, please to apply the provisions to the courts in the state of Meghalaya. Now, the district court shall continue to derive powers under paragraph 4 and 5 of the 6th schedule to the Constitution of India.
Yes.
Now, this certainly means, this notification of 20th September 22 certainly means that it is restricted by 5.1.
Yes.
That we can clarify.
That is one aspect, my lord. Second aspect of the matter is, my lord, page number 142, another conferment issued by the governor to the magistrates in district council courts under para 5. This is one of the second challenge. Lordship, kindly take the pen to read with me page number 145, 142 of the petition.
145.
142, my lord. Now, may I read? It says, in exercise of powers conferred by Sub-Rule 1 of Rule 7 of the Khasils Autonomous District Council, Administrative Justice Rules 953 as amended, Governor of Meghalaya is pleased to approve the appointment of such and such magistrate. Further, next is important matter. The Governor of Meghalaya is in exercise of powers conferred by Sub-Paragraph 1 of Paragraph 5 of the 6th Schedule Constitution of India is also pleased to confer on those officers, my lord, With the powers of judicial magistrate of the first class as provided under CRPC for the trial of offences under the Indian Penal Code or any other law for the time being applicable in the Constitutional Home District Council. Now, Lordship has correctly noticed para 5(1) is for trial of serious offences, punishable with death, transportation. Now, this is beyond the jurisdiction of the magistrate court. It's all accession trial cases. Now, this investment of power is, in fact, provided by the Act passed by District Council Court itself. May not we come to page number 62 of the writ petition. In that very.
Now, this could be in respect to the offences under paragraph 4. Conferment may be under 5(1), but the judicial magistrates and others, that power is possibly conferred in paragraph 4 for those lesser offences.
Now, therefore, conforming, my humble submission is that
This is with regard to the appointment of the judicial officers for the purpose of deciding the cases which are not covered by 5(1), but maybe 4. Because for a murder trial, it cannot be by a magistrate. So this has to be read with in respect of paragraph 4 of the offences mentioned in paragraph 4.
But my humble submission is, my lord, the powers under para 4, governor has nothing to do with the conferment.
Sorry?
My lord, with regard to the power under para 4 of 6th schedule, governor has no jurisdiction to intervene. He has nothing to do to exercise his conferment of power. He can exercise conferment of power with regard to offences beyond 5 years punishment. If my lord kindly see, my lord kindly see para 4.
The rules,
My lord, page number 57.
page 57.
57 of the writ petition.
No, first part you are not objecting, second part only you are objecting.
My lord, that
Further, the governor of Meghalaya, in exercise of the powers conferred under subparagraph 1 of paragraph 5, 6 schedule, is also pleased to confer and such as powers of the judicial magistrate of the first class,
Yes.
as provided under CIPC for the trial of offences. So there has to be a conferment of power. So a conferment of power has to be by any legislation.
By the exit committee. By the exit committee of the district council.
Conferment of power has to be on the basis of an act. It cannot
On the
be.
basis, yes.
So obviously you have to fall back on the CIPC for the purpose of conferment of the power.
My lord, my lord, for allowing the magistrates, district council court to exercise, they have to derive powers from the 1953 rules. Enacted 1953
may I
rules.
explain?
Sorry. Yes.
In order to exercise, my lord, the power under paragraph 4 by the district council magistrate courts, they have to derive the power from the 1953 rules. Lordship, kindly come to page number 53, the rules I'll show.
Kindly give me 2 minutes, my lord.
Yes.
The issue will be 2
Page
minutes.
53.
Yes, my lord.
53.
My lord, paragraph 4 and 5, they are
53 is the rules. Page number 57 of the writ petition. District council has already formulated these rules. My lord, on the top, may say, 18 December 1953, I just remember, exercise the power conferred under subparagraph 4 of paragraph 4 of the 6th Schedule Constitution of India. United Khasi Chendai Hills District Council, with the previous approval of the governor of Assam, is pleased to make the following rules. Namely, it is taken. Now I would come to, under this, my lord, classes of courts are there. My lord, we come to page, my lord,
Approval of the government.
page 63, my lord. Rule 17 is the investment of powers with the magistrate courts.
See whether provided in the Constitution. Shall exercise such powers. With the approval of the governor.
Well, therefore, my humble submission, it depends on the executive committee of district council whether they need to invest the power to the district magistrates, because they know the strength of the magistrates, the requirement of the area. So it is exclusively within the power of within the domain of the executive committee, which is subject to the approval of the governor. Now, what happened by virtue of this notification? Governor has taken away that power and confirmed. According to me, therefore, it is offensive to these rules.
So according to you,
Yes.
that first the executive committee has to decide
Yes.
and then forward it to the governor for
Yes.
his approval. The
Yes,
governor
yes.
may approve, may not approve.
May not approve.
But according to you, this power under 17,
Yes.
paragraph 17,
Yes.
has been taken away by this particular thing.
And that is offensive, denigrate the power of the district council. So my humble submission, my since made the listed for motion today. If Lordship permits, the state respondent district council may file a short affidavit, and Lordship may settle the issue expeditiously. Let them file the affidavit.
Lordship, kindly see paragraph 4.
You have filed your affidavits.
No, my lord, this is coming for the first time.
First time.
First time.
You filed your affidavits. Sir.
Yes.
But the issue is, my lord, in paragraph 4, the district council has power to constitute the court.
Anyone appearing for the district council?
District council by Friday is it?
Very well. This matter Yeah. So you have to state. Yes. Yes.
Be pleased, my lord. My lord, this is the review application against the judgment and order dated 19/8/2025, passed on writ appeal number 51 of 2024, my lords. Your lordships here, my lord, the matter pertains to the, initially the matter pertains to the appointment of a judicial magistrate, my lord, in a district council.
Yes.
Your lordships, here in the year 2019, advertisement, my lord, has been floated for filling up a vacant post of free magistrate, my lord, in the subordinate district council court, Shillong. When, my lords, the procedures has been followed, examination has been conducted, and in the year 2021, my lord, the executive committee has declared the list of the successful the candidates in order of merits, along with the list of the candidates
you
of
are,
waiting
you are,
list, my
you
lord.
are the
Your lordships, I'm for the district council, my lord.
you're for the district council.
Your lordships,
You seek a review of this order.
my lord.
So here the council in the state was directed to create one supernumerary post.
Your lordships, yes.
No, but what is the ground for review?
No, my lord, here, initially, your lordships, when the appointment of the private respondents number 4, 5, and 6 was challenged, my lord, the learned single judge has dismissed the writ petition.
No, what is the ground of
My
challenge?
lord, your lordships kindly have the order, my lord, at page 44. The operative part, my lord. Your lordships kindly have page 45. No, my lord, here direction has been issued by this court to create one supernumerary post, my lord. My lordships, we are here with regards only with this to the direction with regards to the supernumerary post.
No, why the ground to review? That's what I'm asking you. What is the ground of review? If you are aggrieved, you go up and prepare an appeal. But what is the ground of review? There is no ground for review. There is a discussion, reference to various cases, facts and details and views.
My lords.
So everything is discussed. So what is the ground for review?
No, my lord, our only ground for review is only with regards to the direction issued by this court for creation of one supernumerary post, my lord.
So out of the 3 posts, only one.
My lord, there's an existing one vacancy, my lord, but that vacancy is also pertaining to the post of the additional judge, not for the post of the judicial magistrate. My lord.
So the division bench accepted the supernumerary post for which this judicial officer is required to be considered was based on a grave urgency to fill up the vacancies
My lord.
for the speedy cause of judicial administration. This is a reasoned order. We have nothing to do with this. Take down.
My lord, sir, I just pray that the matter will come after a week because your lordships I've been led by a senior counsel, my lord, here in this matter. Since he is indisposed, my lord, I pray that the matter may be adjourned for today.
You are appealing for,
Well, I appear for the writ petitioner appellant.
and you are for
For a state, your lordship.
a state.
They are private
say,
respondents
my lord,
as well, my lord.
Is it appealing for the first time?
My lord, this
No,
is
but
the second
notices
time,
had been
notice has
issued,
been
my
issued, my lord, to the private respondents, 4, 5, and 6.
If it may please your lordships, I've received instructions to appear for the private respondents. I'm entering my appearance.
Respond
today.
numbers?
4, 5, and 6.
4, 5, and 6. File
Please
my
give the
authority
appearances.
in the course of the day.
You are the
For the
They
respondent,
were the
4, 5,
selected
and
candidates,
6.
you are the selected candidates, but your service is not being affected.
Your
have
lordship.
not been touched.
Your service is not being touched.
Your lordship.
But what is the ground for review? We don't understand. Ground for review.
To succeed in review, my lords, they would have to come within the parameters of Order 47.
There is no ground for
Your lordship,
review.
that's why my humble prayer, my lord, for today.
Dead
It's a
on.
week's time, my lord. Will be granted. Will be adjourned for today.
So you are seeking an adjournment on the ground of your senior.
Lordships.
After we heard this matter for some time, a prayer for adjournment is made on behalf of the Land Council, on behalf of the applicant as the senior advocate engaged is not presently available. We'll stop. All the respondents are represented. All the respondents are represented. Let this matter be listed on.
Three.
My lord, pertaining to this matter,
This one. Yes,
But for response, I'm required to file affidavit here, my lord. It is in the process of filing today. But there was because of some annexes were not very clear, so we are filing it today, my lord.
on the prayer of the learned.
Here we have come against the order of the Central Administrative Tribunal, my lord.
Yes. Yes.
But the only issue involved here is with regard to date of next increment, my lord, DNI. Lots of aware there are the system has been streamlined, my lord. Now there are two dates of increment in a year, my lord. One is 1st July and one is 1st of January, my lord.
Yes.
Now here, my lord, if lordship kindly sees page 27,
This is judgment of 20th March 2025.
yes, my lord. The issue is a very simple issue in this matter, my lord. In fact, there's a factual error in the tribunal's order. Here, what happened, my lord, if I may submit, date of increment is either 1st of July, my lord, or 1st of January.
I think in paragraph 5 of the judgment, it is it? Something appears to be incorrect. I don't know.
Lordship, permit me. I'll
In the
just
present case, the OA was filed on 13th March 2025. What is the case here? When he retired? He retired on
he retired on
December 2023.
31st December
And the
23.
increment was on from 1st Jan 2024.
My lord, that is a factual error. His date of increment was 1st of July, my lord. So that is where the problem is, my lord. If I may take your lordship to two documents, my lord.
1st of July.
My lord. My lord, what Supreme Court said, my lord, that if somebody is retiring on 1st of January, that is only for the purpose of formalities, my lord. Because he worked till 31st December 2000 of any particular year, my lord. So he has earned the increment by serving for 12 months, my lord. So that's why Supreme Court said that if somebody is retiring on 31st, the increment that is given on 1st of January should be given to him. But here is a case, my lord, his increment becomes due on 1st of July, my lord. A lordship will find that at page 27, my lord.
No, in paragraph 4.7, it said he retired on 31st December 2023.
31st December 23, my lord.
Yes.
Now, my lord, his increment was due on 1st of July of every year, my lord. Lordship will find that at page 27. If Lordship kindly comes to page 27, my lord. At serial number 4, DNI, 1st July 15.
Page.
27, my lord. At serial number 4, DNI is the date of next increment, 1st July 15, my lord. Similarly, page 64 also will indicate, my lord.
What is DNI?
Date of next increment. Similarly, at page 64 also, Lordship will see.
Page?
64.
So every year it is in July.
It is in July, my lord. In his case, my lord. So now he will not be entitled to increment on 1st of January, my lord. He retired on 31st December. Hadn't DNI been 1st of January, my lord, he would have been entitled. But because his DNI is July, my lord, he only completed 6 months of service on the date of retirement.
So according to you, that since it was not the very next date, so this judgment has proceeded on the wrong premise.
My lord. My lord, if I may take your lordship to page 20, my lord, of the tribunal's order, the relevant para which they have relied on, my lord. At page 20, they've quoted para 7, my lord.
And the ratio is this, that the entitlement to receive increment therefore crystallizes when the government servant completes requisite length of service with good conduct and become payable on the succeeding day.
My lord.
So according to you, if this payment is not payable on the succeeding day
My
of
lord.
retirement, so the ratio of the judgment would not
Will
apply.
not apply, my lord.
Yes, it means.
From subpara 7 at page 20 is very clear, my lord. The office member, if he's retiring on 1st July, and if his DNI was 1st July and he was retiring on 30th June, since he completed 1 year of service on 30th June, my lord, since last date of increment, only because his date of increment on the next day will not disentitle him, he will be entitled to, my lord. But here is a case, his DNI is 6 months later, my lord.
Yes, what do you say?
Lordship, yeah.
Yes.
May I, Lordship?
Yes.
Yes, Lordship, yeah, we have filed the affidavit also on behalf of the respondent, Lordship. So, Lordship, today may I pay that Lordship, that matter may be hard physically because of personal difficulty from Guwahati, Assam. I
No,
could not come, Lordship.
is it appearing for the first time?
Yes, Lordship, it's
Yes,
for the
Lordship.
first time, Lordship. I am appearing for the first.
No, it's the 4th time today.
No, we have received notice. Lordship, after receiving notice, we are appearing for the first time. We have filed Wakalatnama on the last occasion only, Lordship. And we have filed our affidavit also, Lordship.
All documents are here on
Yes, my lord.
take down. Pursuant to notice, the respondent is represented. We have heard the learned DSCI. Yes.
May I please, Your Lordship? Your Lordship, in this matter, we're supposed to file our rejoinder, Your Lordship.
You are appearing for?
This petition, Your Lordship.
You are not appearing.
I apologize,
On
Your Lordship.
two occasions.
There were some
Yes.
emergency, Your Lordship. The rejoinder has been sent to Delhi for vetting, Your Lordship, since it's department matter, Your Lordship.
But madam, where you are not appearing, that's the point.
I apologize for that, Your Lordship.
Your good name is?
MSEB Pasar, Your Lordship.
But you, E.B. Pesa.
Yes, Your Lordship.
Who is the arguing counsel?
Your Lordship, my senior, Mr.
Hello there.
K.
You are appearing.
He's
For
the
respondent,
Your Lordship.
sole
Yes, who
respondent.
is the arguing counsel for the appellant?
Mr. K. Kharmoplang, Your Lordship.
But where is he?
Your Lordship is indisposed as of right now.
Yes. Don't require any affidavits. Whatever before the tribunal you file in a compendium will decide the matter.
Your Lordship, it's required, Your Lordship. There's some facts you want to place, Your Lordship.
See, we are deciding a writ petition arising out of the order of the tribunal.
Yes, Your Lordship.
So we are only going to consider whatever the pleadings and documents were there before the tribunal.
Lordship.
If you are intending to file a fresh document for which you have to obtain a leave.
Lordship.
So, whatever documents you have filed, there is no necessity of any affidavit.
Lordship.
Where is the necessity of filing an affidavit to this? So, there is no necessity.
Lordship.
Only you have to file the full set. Stay down. After hearing the learned counsel for the party.
May I please, Your Lordship, I'm seeking accommodation for this matter, Your Lordship.
You want adjournment?
Your Lordship.
When, madam?
Lordship.
Same thing, you are not appearing.
Lordship, this matter pertaining to Accountant General Audit, Your Lordship.
No, that we know, but
Yes, same parties, Your Lordship. the respondent is the same person.
No, this is also arising out of the
Yes,
judgment of
tribunal,
the
Your
CAT.
Lordship. Yes, Lordship.
What are the previous orders? Who is appearing for the respondent?
Yes, I am appearing. I am appearing for the sole respondent. I filed my affidavit division, they filed their return their affidavit.
No record of
Hearings are
affidavit. We
complete.
have no requirement of any affidavit
Yes,
because
yes.
no fresh
Yes.
document is there. No
Yes,
fresh
yes.
document is there.
My lord, all the documents are in the record, my lord. What was produced before the land
Same order as previous. Same order as previous. Only thing
matter
there
may be
is
heard
no-
in the hearing, my lord.
Only thing there is no interim order, so just omit the interim order. We don't find that there is an interim order passed in this matter.
We have not filed any contempt petition.
So no interim order is required. Yes.
May I please, Your Lordship. Your Lordship, my apologies, Your Lordship. In this matter, Your Lordship, the conducting counsel was here. However, due to some emergency, she had to leave, Your Lordship.
I'm fresh with the bench, so you have to. You are for the petitioner.
I'm for the
No, I am for
respondent
the
state
petitioner,
respondent, Your
You are
Lordship.
for the petitioner.
Petitioner,
You are for the state of Meghalaya.
Yes, Your Lordship.
So let him begin, or what you want? Let him begin. Let us understand what is there in the matter.
Yes, Your Lordship.
Yes, ma'am. My lord, the petitioner herein, my lord, there are 15 petitioners, my lord.
Yes.
But we challenge the two Amendment Act passed by the
Amendment Act.
Yes, my lord. We challenge the virus of the two Amendment Act passed by
You have challenged the virus.
virus, my lord. Yes, my lord. Because, my lord, the brief facts of the matter is, my lord, the petitioners herein are the district council law primary teachers, my lord. Prior to the, my lord, prior to 1980s, my lord, the lower primary schools were administered and run by the district council.
Have you filed your paper book?
No, my lord. It's a writ petition, my lord.
Division.
Where is the act?
File your affidavit.
Yes, Your
My
Lordship.
lord.
we
Pleadings
filed
are
our-
completed.
We had also filed an additional affidavit, Your Lordship.
Yes, my lord.
You have also filed your reply.
No, my lord.
When you file your reply,
No, I have
you
not-
don't require to file a reply.
No, my lord. Because since it is fixed for hearing, my lord, from last 3-4 occasions, my lord.
No, you don't want to file a reply to this.
No, my lord.
Very well. Yes, tell us what is the matter.
Yes, my lord. Prior to 1980, my lord, the lower primary schools were run by the district council, my lord, in West Karo Hills, in all over Meghalaya, my lord. Then, due to the failure on the part of the district councils to run and manage the affairs of the schools, lower primary schools, the governor was appointed an administrator, my lord, which power flows from 6th schedule, my lord, para 16(2), my lord, of the constitution. Then, my lord, the petitioners were appointed by the administrator in the year 1992 and 1993. Different dates, my lord, different years. Then, my lord, the government of Meghalaya come out with an enactment called Meghalaya Lower Primary District Council Act, my lord. The Parent Act, my lord, 1994. Under the said Act, Section 3, which provides some benefits to the teachers, my lord. Then, my lord, the benefits were not provided to the teachers. Then teachers were approached before the Honorable High Court at Guwahati, my lord, the bench. Then the Guwahati High Court has passed direction to release the benefits under the Section 3, which benefits were occurred, my lord. The benefits were released. Then, my lord, there's 2 sections under the DCLP teachers, lower primary. One is basic, basic school teacher, one is pre-primary teachers, and one is lower primary teachers. And petitioners herein are the lower primary, pre-primary teachers, my lord. So, my lord, then, my lord, the pre-primary teachers were approached before this Honorable High Court, my lord.
Yes.
Writ petition number 208 of 2015, my lord. The Honorable Single Bench of this Honorable High Court, my lord, after hearing the matter, was pleased to direct the state respondent write judgment and order dated 17/5/2017, whereby it's held that since in the Parent Act Section 2E is silent about the meaning of the DCLP teacher, therefore pre-primary are also included and within the ambit of the Section 2, and direct the state respondent to release the benefit which occur under the Parent Act. Then, my lord, the state respondents filed an intra-court appeal before this Honorable Court. Then in the appeal, my lord, this Honorable Court Division Bench, my lord, Honorable Division Bench had upheld the order passed by the learned Single Bench and discussed the, my lord, aim and object of the Parent Act. Thereafter, my lord, the state has appealed before the Honorable Supreme Court, and then again contempt petition is filed, my lord. During the pendency of the contempt petition for releasing of the benefit, the state respondent come out with two amendment, my lord, in the year 2018, whereby the first amendment to add the Section 2E definition clause, whereby they have excluded the pre-primary teachers, my lord. Kindly have page, my lord, annexure 8, my lord, the first amendment. They have excluded the pre-primary. Then second amendment, whereby Section 1 has been amended and the cut-off date has been fixed as 2/6/1994. Thereby we are affected, my lord. Then the same set of teachers, my lord, were approached before this Honorable Court. Then challenging the virus of both the amendments. During the pandemic.
Virus on what ground?
Yes, my lord. Virus, my lord, on the basis of, my lord, the amendment were passed in violation of the section, in violation of the Article 14 of the Constitution, my lord. And second is, my lord, the amendments were manifestly arbitrary, my lord. And third is, my lord.
So by the amendment you were excluded?
Yes, my lord. We are excluded with the benefits occurred under the Parent Act, my lord.
So according to you, the Parent Act gives you some power, some other right.
Some right, some benefits.
So that right was being withdrawn by the amending act.
By the amendment. We are excluded. We are excluded by the amendment of the Section 2E definition clause, my lord. The amendment was come under, my lord, during the pendency of the contempt petition. And now by this amendment, my lord, the legislature has encroached into the power which is exercised by the judiciary, my lord, because there is a judgment which attains finality, my lord. Now, by this amendment, they nullify the judgment of this Honorable Court, which is impermissible, my lord.
No, if the basis of the judgment is altered, then it's fine. But if it is There's a fine line of distinction between the two.
Yes, my lord. But subject to scrutiny of this court, the subject to the amendment has to in consonance with the Article 14 of the Part 3 of the Constitution. The amendment has to reasonable, not my lord, not in violation of the Article 14, my lord. They have the power to amend, my lord, subject to the judicial review of this honorable
You
court.
say that this amendment is to circumvent the provision, the judgment.
Yes,
is one
ma'am.
thing.
Yes, ma'am.
But if the amendment is change the basis of the judgment, and there is some reason for this,
Yes, my lord.
then this may not be, if the basis is altered
Yes,
to
ma'am.
some extent, then that's a different issue, and you still can say that is ultra vires on different ground,
Yes, my lord.
but not strictly in violation of the judgment.
Yes, my lord. Now, the first ground, my lord, is by this Amendment Act, my lord, they have discriminated, my lord, because the benefit which is already given to the in other writ petitions or amicably matter was settled, my lord. They have also challenged the vices of these two Amendment Acts. During the pendency of the writ petition, the state government has come amicably settled down the matter and released the benefits. Now we are left behind, my lord.
No, your benefits have not been released, or
not been released, man. Because of this amendment, we have right to the department.
you have become disqualified.
Yes, my lord.
The amendment has disqualified you.
Disqualified the petitioners because the amendment, section 2, is been added, my lord. And by the amendment, we are excluded. Previously, the act was silent, which is why, my lord, the honorable single judge of this honorable High Court has held, since the act is silent, and aim and object of the parent act was discussed. 1994 act was discussed.
No, but you are not expressly included in the parent act.
We are not expressly included.
But by reason of the judgment of this court,
yes, my lord,
you are included.
We are included, my lord.
So that inclusion is now again excluded.
Again excluded by the amendment in 2018.
So possibly in the amendment they have expressly excluded you.
The amendment has expressly excluded now, my lord.
Because the judgment proceeds on the basis of by necessary implication you are being added.
Yes, my lord. Because in the single bench judgment, my lord, the honorable single judge, after hearing, they have discussed the aim and object of the act, my lord. The aim and object of the act was to take over the primary education, my lord, and provide some benefits to the teachers. That is the only purpose, to cater education in Garo Hills regions, my lord, under the same act, and provide some benefits under section 3, which is in the parent act. Then the same was appealed before the intra-court appeal, and again in the honorable division bench, the division bench also discussed the same thing, the aim and object of the act, and upheld the order passed by the learned single bench. So we are protected under the two orders passed by the honorable court.
But by now of amendment, you have been expressly excluded.
Expressly excluded, my lord. Which is why we have challenged the Amendment Act, my lord. Which is in contravention with Part 3 of the Constitution, my lord. Because the scope is limited, my lord, with regard to the nullification of the judgment, my lord, by the legislation.
So you have given the judgments and everything are on record.
No, my lord, I have filed my list of judgments, my lord. The previous occasions, my lord. This is the first time come before my lord, my lord.
Is appearing for the first time?
Is appearing before the first time before my lord.
First time?
Yes,
now, before it was heard?
Before it was partly heard, my lord, before the predecessor.
So what are the compilations?
File any compilation, my lord. It was heard, but
but you have to file a short notes of argument.
My lord, we can file, my lord.
You file it and with a compilation of judgment.
Yes, my lord.
Give it to your learned friend, and you also, madam, file your notes, written notes of argument.
My lord, yes, madam.
Write down. We have heard the learned counsel. copy of the list of the case, list of the cause cases